SJC-13109, the Masonic Temple Association of Quincy, Inc., v. J. Patel.
Okay, so we'll start with Attorney Pickering Cook.
Yes, good morning. May it please the court. My name is Nina Pickering Cook. With me is my partner, Steve Schreckinger. We represent the Masonic Temple Association of Quincy, referred to in this case as the Masons. We're going to be dividing the appellant's time this morning with 10 minutes for Masons counsel to address the DBA issues and 5 minutes for DIPICA's counsel to address the claims against Roblin. With the court's permission, given that I am going early in this lineup, I would like to reserve 1 minute of time.
Well, you know, we don't do that, so.
Understood, Your Honor.
Okay.
Now, Union argues that the policy it issued to DIPICA is limited to the Super 8 in Weymouth based solely on a single notation on the declarations page of quote, DBA Super 8, unquote, under the named insured. That notion that this 3-letter descriptor that has no legal significance is decisive is inconsistent with the rest of the policy and inconsistent with the decisions of this court. Turning first to the policy, Union argues that the policy doesn't cover DIPICA's construction at the Masons Temple. Yet the policy contains 2 endorsements that essentially say, we cover you for all construction projects and we cover you for operations at all locations. Those endorsements can be found at Record Appendix Volume 1, pages 208 and 210.
Aren't the words may in that language? It's not a mandatory, it's a may include, it may be extended, right? If you read the exact language about extensions for a second.
As far as what the endorsements cover?
What you're saying that the policies allow the extensions, right, for construction, right? Is that the argument you're making?
Correct, that the policies include an endorsement that covers all construction projects.
I thought it said it may be extended, the exact language. Am I misremembering the
Well,
language?
adding the endorsement to the policy extended that coverage. This is an endorsement for which the insured paid a premium.
He sure didn't pay an additional premium for anything, right? He paid a premium for the DIPICA DBA Super 8 Washington Street, Weymouth, right? That's what it did.
If you look at,
He didn't get any, they didn't pay more. He didn't increase his premium to pay for the additional coverage you're talking about, right?
if you look at the second page of the declarations page, there is a line item that lists endorsement premiums. And he pays an additional amount for the endorsement premiums as listed on that page.
When you say the premiums, though, how were the premiums calculated?
I can't answer that, Your Honor. That's
Because isn't that part of why they say that it's not covered? That whatever he was doing at the Mason site, if you look at how the premiums were calculated?
Your Honor, that may well be what the insurer intended, but what was issued to the insured here was a policy that had no limiting language in it anywhere, right? So if the insurance company intended to limit the policy to DBA Super 8, it could have done so in a number of ways. So first of all, those endorsements could easily have been written to say, instead of all projects and all locations, all Super 8 projects. All Super 8 locations. It didn't say that. In addition, the Masons have an expert in the insurance industry that testified there is recognized insurance standard language that you add to policies when you are intending to limit them to a single operation or a single location. And the insurer did not do that here. Now, whether they thought they were insuring just the Super 8, we don't know. We base our decisions based on the plain language that's reflected in the policy. This court has already decided the issue, although it did not have this DBA notation, but the Tufts issue is squarely on point with the underlying issue here, which is what does an insurer need to do to effectively limit coverage? What do they need to reflect in the policy to effectively limit coverage? So in Tufts, the insurer argued that the policy did not extend to activities of a Tufts subsidiary because that subsidiary was not listed on the scheduled hazard under the policy. Now, the court rejected that argument, and it held that if insurers want to limit coverage to a specific hazard, they have to do so unambiguously. In fact, the very quote, which I believe both sides have cited in their briefs, says, quote, "Nowhere does the policy unambiguously provide that coverage is limited to the specific hazards listed in the schedule." Now, that ruling is directly applicable here. Union cannot dispute that nowhere in this policy does it use the words to the effect that coverage is limited to the Super 8 in Weymouth. The court cannot infer a limitation where there is none. And that is what Union is asking you to do here. Infer from one mention of a DBA, a limitation that applies to the entire policy. Now, it's said.
Can I ask again, I'm focused on exact language. The newly acquired, are you the newly acquired or constructed property? That's the basis, because the policy talks about it as doing business at this particular address, but I take it you're relying on the fact that the policy also has language that you can acquire additional buildings or things like that, right?
I'm sorry, Your Honor, that you can acquire additional.
Buildings, the newly acquired or constructed property provision is that what you're relying on?
No, what we're relying on is the fact that nowhere in the policy is it limited.
Oh, but
Nowhere.
the policy describes what it's for, which is this doing business at a particular address, but it allows for additional flexibility, but you're not relying on that either?
No,
So-
it does, Your Honor, but we're also relying on the fact that it's settled law in Massachusetts that under commercial general liability policies, as the amicus point out, the insured covers all risks that are not explicitly excluded, and that includes risks that the insured may diversify and expand. What happened here
Who
is
is the insured under the policy?
the insured is Dipika Inc. If you look at the declaration page,
Now, where is that?
the declaration page, I believe, is Record Appendix 1, page 82. The Record Appendix, that declaration page lists the insured as Dipika Inc. On the line below, it says DBA Super 8. But the declarations page also has additional descriptions for the form of business is listed as a corporation. Super 8, DBA Super 8 is not a corporation. Only Dipika is a corporation. And the insured business is described as hotels and motels. What Dipika was doing at the Mason's Temple was a permitted construction project.
So, counsel, let me test you on that, or push back a little bit on that. One of the counter arguments here is that you are referring to Mr. Patel and Dipika as if they're one and the same. And that what was undertaken at the Masons or at this project was by Mr. Patel, not Dipika.
Your Honor, that's a disputed issue of fact that is yet to be resolved in this case, whether Dipika Inc. is the liable party here. What is in front of the court now is what is the policy cover. The policy clearly covers Dipika Inc. The Masons have alleged that Dipika Inc. caused that fire, but that liability is yet to be determined.
But the assignment was to Patel.
Right.
Correct, that the assignment was to Patel. There is other evidence that Dipika Inc. Undertook the construction, including the testimony of Jay Patel himself as the principal of Dipika Inc., as well as the payments made to the workers that caused the fire were from checks issued by Dipika Inc. So that is very much a disputed fact. That would
Call
need
to
to
the
be.
broker. How does he identify himself on the call to the broker?
On the call to the broker, he said, "This is Jay Patel. I need coverage for Dipika Inc." If you look at the exact quoted language, he said, "I need coverage for Dipika Inc. for the Mason, to cover the Masons as a lost payee." He says nothing about the Super 8 motel. Clearly, the insured here thought that his corporate entity under which he was doing work for the Masons was covered under this policy. Now, even if your honors find that the,
I'm sorry, can you tell me again, where is the identification of the insured?
the declarations page, which I believe is Record Appendix, Volume 1, page 82,
82, okay, thank you.
I think it's 81, isn't it?
81.
Yeah.
I apologize. Now,
And so on this declarations page, what is your position that DBA Super 8 means?
well, that's a good question. It
Yeah.
is, at the most, I can say it is their choice of how they describe the insured. At most, it clarifies perhaps that the Super 8 is also covered under DIPICA Inc. But it does not limit it.
It would be redundant to say.
I'm sorry.
It would be redundant to say DBA Super 8 as exemplary, right? Why would you, if it's all DIPICA, why would you DBA Super 8?
I'm purely as a clarification. There's nothing in the policy that tells us,
Clarification of who is the insured?
or a clarification that it's extended. It's certainly not an unambiguous limitation.
Why
It does-
not? Why not?
Because it does not say this policy coverage is limited to DBA Super 8.
Well, it does
does
say
not-
that that is the named insured. I guess I'm trying to figure out, what does it mean if it's not just Super 8?
Nothing in this policy tells us what that means.
But I'm
which is
asking
our
you about
point.
this declarations page is telling me something. And I'm wondering, under your construction of this policy, what does DBA Super 8 mean? You're just saying it's exemplary?
I'm saying I think it's inconsistent to give it any legal significance under the policy where Massachusetts law does not recognize a DBA as a legal entity. DIPICA Inc. is the entity that is liable for the payment
So
premium. to
you're
pay-
saying under Massachusetts law, this Tufts case, the named insured must be a legal entity.
Yes, Your Honor. The named insured is a legal entity. It's described as a corporation on the declarations page. What we are saying is that notation of DBA, unless it's otherwise addressed in the policy, that one designation is not enough to unambiguously limit the policy as required by this court in Tufts.
But what does it mean? Every word in a policy means something. And I'm trying to figure out what your position is as to what DBA Super 8 means.
Sure, to the extent it means anything.
And it must, under our rules of construction.
I think the only explanation we can have, well, there's two. It could clarify that the Super 8 is actually included in the coverage, or it is.
But why, can we stop there? Why would that make any sense? If DIPICA Inc. does business as Super 8, why would it clarify that? Why wouldn't you just say DIPICA Inc.?
Well, because that's all DBAs are, right? All DBAs are.
I know
are
what a
descriptive.
DBA is, but
So
presumably DIPICA Inc. does more than just the Super 8 business.
Is that true? Does it do more or not?
No, I don't think it does. I think the named insured is just, the named insured is a description. The DBA within that named insured is a description. It is not a limiting factor under the policy. If you look at the entire
I've
policy.
heard that, but I'm trying to figure out what it means. So DIPICA Inc.
Honestly, I think it is, if in fact the insurance company intended it to be a limiting factor, they did not do so appropriately, right? And to the extent they made a mistake and they did not limit it, they used that as a limiting, to try to limit coverage. They didn't do so appropriately. And the insured in this case cannot pay for that sloppy drafting by the insurer.
Can I ask, you don't make anything of the next page. I'm just going to page 82.
Yep.
So on page 81, there's also at the bottom of the page, it goes location of all premises you own, rent, or occupy. On the next page, it goes hotel, motels without pools or beaches less than 4 stories.
Yes,
Is the Mason building, how many stories is that?
it is 2 stories in a basement. I would also point out again that there's
So, but
plural
you
there,
don't make
this
an
is-
argument based on that, or you don't make an argument based on that, right? I mean, I read a lot of briefs over the weekend, but you don't, did you ever say, oh, because of this second provision, we're covered, or no?
well, that's certainly, it's all consistent with our argument that nothing, it's not limited to just one hotel or motel here. Dipika Inc. was expanding. It was the same
But I'm
coverage,
confused
hotel
by this.
operations.
I'm confused. So this guy operates a hotel somewhere,
Sure.
and then he buys, he becomes an investor in, you know, the Bellagio in Las Vegas. So he's covered? He did, you know,
Well,
so he buys some gigantic casino in Macau. He's covered? I mean, I'm just like, it doesn't make any sense to me. You
If
gotta
he-
pay for something if you want more coverage, don't you?
If he is the, I think if he's just the investor there, then that's a different circumstance. But if he is the owner and it is bought under
No, so
Dipika
let's
Inc.
do an example. He buys the Ritz in Back Bay. He becomes the owner of the Ritz. Some
Sure.
giant hotel that's brand new. Is he covered under your interpretation?
Under Massachusetts law, commercial general liability insurers take the risk that their insured is going to expand businesses. That's why these renewals come up every year, right? Every year there's a renewal where the insurer steps in and takes another look at the risk. But in the meantime, as long as we're talking about hotels and motels, expanding to a hotel and motel under 4 stories, and construction projects related thereto, that's covered under this policy. There's nothing that says it's not covered.
How, in your view, could Union have limited its coverage to the Super 8?
How could the union have covered it? Sure. So we have an expert who provided testimony that there at least.
I'm just dealing with contracts. I'm not interested in, extra non-contractual evidence. How could he have limited?
Sure, there are 3 separate standard.
Because you're saying Super 8 was not a corporation, right? And
Sup-
And under
Right.
your view of the Tufts case law, the named insured must be a legal entity. Super 8 is not a legal entity. How does Union identify we're covering Super 8 and that's it?
I understand, Your Honor, quite easily in 2 different ways. The first way is under the endorsements. Instead of, again, endorsements are pre-printed policy, pre-printed pages, right? And then they type in, the insurance company types in for each policy what they want to cover under that endorsement. And under these endorsements, Union typed in all projects and all locations.
But that could
They-
refer back to the DBA, right?
It
They
does.
very easily could have said all Super 8 projects, all Super 8 locations.
But they wouldn't have
wouldn't
to
have to-
if, they wouldn't have to if the premise is that it's insuring and you paid for insurance for just the DBA.
But the second reason, Your Honor, is that there's also standard recognized insurance language that gets added if you were trying to limit it to a specific hazard or a specific operation or a specific location.
But
We've
if
outlined what
if
those
I'm
provisions-
Union and I want to do all projects, all hazards, everything, but it's just the Super 8.
Sure. There is a specific provision, I believe it's called the designated operations endorsement, that they could put in and say, I designate the coverage here to be limited to the operations of the Super 8 in Weymouth. That would unambiguously limit this policy to, as Union argues, it's so limited. That is not in this policy. All we have is a reference to DBA Super 8 that no one knows what it means. If we are looking at Massachusetts law as.
When you say nobody knows what it means, can you articulate what you mean by that?
Well, what I mean is, We believe it has no legal significance.
Well, of course.
They
What's
believe
the
it's a
legal
limiting,
argument?
they believe it's a limiting factor.
Yes.
Under Massachusetts law, if your honors believe that creates an ambiguity, then the insured
Well, yeah,
wins.
then we get into all sorts of parole evidence and yada, yada, yada. But if
Right.
we think it's clear, what's your position?
We think it's clear because under the Tusk case and under the GRE case, there needs to be an unambiguous specific limitation to the effect of coverage is limited to the Super 8 in Weymouth. That those words don't appear anywhere in this policy. Under GRE, to your point of what could they have done? Under the GRE case,
The GRE case is really not helpful for you because that just defined business type as office, which was, relative to whether or not it was a hockey rink, not a particular office location. How is that helpful to you?
the GRE case found that although there were many more descriptions of limitations than we had here, it found that the failure of the insurance company to use specified standard insurance language in an endorsement to limit the policy was fatal to their argument that the policy was limited. That's exactly what we're saying here.
Okay, you got more than that, more than you bargained for there. Thank you very much. Why don't we have Attorney Lawler now?
Good morning, Your Honors. David Lawler on behalf of Deepica Inc. And Jay Patel. And I'm here to address the issues specifically involving Deepica and Roblin. Really, in reviewing the situation, the first issue here is the disclaimed coverage by the insurance company union with respect to the claim for coverage and whether or not they should have actually indemnified and also provided at a very minimum a defense to this matter. This factual circumstances are very important. Here you have an issue where you have Deepica paid its premium, purchased a product. It's a insurance, an invisible product, but a product nonetheless, and comes and makes a claim for relief under that product. And within a matter of days, receives a letter threatening a lawsuit from that insurance company to its own client, saying, if you persist with this particular avenue, we're going to sue you. My client at that point in time, Deepica, found itself in a very difficult situation where it was being threatened to be sued by the Masons and various other individuals and entities. And clearly, union had not done its due diligence and conducted a proper analysis in this and issued a denial based upon the limited facts, under these circumstances. And the claim, at a minimum, it had a duty to defend Deepica and then file a DEC action if that was, that was the appropriate avenue of relief. And they failed to do so. They got a claim, they issued a denial and left their insured, just hanging out to dry, for lack of a better term. But the real meat of my argument I want to address towards the agency itself and Roblin and the simple negligence. I want to be clear up front. We're not claiming a special relationship here with respect to the agent and the broker. I mean, the client and the broker. What we're claiming is that the actions of Roblin in dealing with my client's request, Deepica's request for coverage. That's what they requested. He requested coverage. Now, he was inarticulate in requesting coverage.
Why don't you use his exact words and the exact response, the words of the response too? Because, and then also get into the follow-up, which he never bothered to respond to.
Well, I think the exact words are, I have them written down here. I need a rider for Dipika Inc.,
Mhm.
Dipika. Naming the Quincy Masonic Temple Association as a lost payee. Those are the exact words.
He doesn't say to them, I just bought a hotel. I mean, I just bought a giant building. I need you to get me coverage for this giant building, right? He says, I need something in 30 minutes and I need them to become the lost payee for that, right?
But he never said, I need a certificate of insurance. And that's what he was given. And if you look at the totality of the
But
circumstances,
that's because that's all they could give him based on the information they have.
I
right?
respectfully disagree. They could have given him nothing.
But let's-
Then that would have
here's
prompted-
The problem, though, the problem is everyone gets in trouble when they don't return telephone calls. And she doesn't, they don't know what they want. They're not sure. And then there's no return call back.
What they gave, they didn't, that's the issue. And that's an issue of fact, Judge, as to simple negligence. And that's not for the trial judge. That's for a jury or a trier of fact, respectfully. What they did is, and this is important because you asked the response, COI attached, okay? But the next 3 words, for your records, not for the Masons, not for this or that, for your records. He had requested something that he reasonably thought an insurance matter. Yes, he used incorrect and uninsurance-like language, but certainly language that a lay person, a person in the hotel business might use. And the person who should know the proper insurance language just guessed, oh, you need a certificate of insurance. And they gave him that. And the totality of these actions, the circumstances in themselves, lead itself to negligence because he asked for something. They didn't know what it was, so they gave him something he didn't need and didn't want and said, it's for your records.
And then didn't they follow up though?
There was one email, but he received it. There's a following email the next day. He thought he had received what he was asking for. It didn't say this is urgent, call me back. It didn't say any of this. It's almost, Judge, when do you stop looking for your keys? When you find them. And in this situation, he thought that he found what he needed because the insurance broker gave it to him and said, these are for your records. He thought he was done. He's trying to develop a hotel. He's a busy guy. And it's hard to, and I know it's one of the faults of lawyers. You need to return phone calls. I couldn't agree with you more, Your Honor. But the issue is simply, it's a negligence issue, and it's an issue of fact. And I don't think that, respectfully, that the trial judge had the ability to judge that fact, because here you have the actions. I'm not alleging it's a certificate of insurance. I understand the case law on that. What I'm alleging is the total circumstances was negligent. You have someone who comes to their agent, a professional, and they made a mistake, and they acknowledge they made a mistake. They gave him the wrong thing. And the simple transaction.
I don't think, they don't acknowledge they made a mistake. They say the opposite, right? They don't know what he wants. He's left them a message. He's also given them like 30 minutes to respond or something. How much time does he give them to respond? He gives them, I need something right away. What is his language?
I need a rider for Dipika, the email. I don't think there was a time limit. That's why I don't think there was a time limit. I think we stressed
to
in the
do
brief
a
that it was
lost
very quick.
payee name of Quincy Masonic Temple, and this is something I need right away.
But he didn't say I need a certificate of insurance right away, and that's what they gave him.
I'm having trouble understanding why he would think that he wouldn't have to pay anything extra, or there wouldn't have to be some sort of discussion about how he would get this. I can't imagine. I mean, I know nothing about this insurance and business and stuff like that, but I would assume that if I'm asking for somebody for something completely different to be insured,
Well,
I might have to pay extra for that.
I can't, I don't have a, well, I'll give an analogy. I have a vehicle. I can give it true. I live in Cape Cod. My child took a vehicle to Boston. The premium goes up. They give notice. They don't demand money right away. They send your bill in the mail for the additional premium. I mean, that could be the same circumstance.
What if you buy a race car? Because that's what this is. It's not, they didn't just add like a shack to their existing hotel. They bought a gigantic building and they're going to renovate it. That's like, don't you have to pay for something that big? It's different. And don't you have to let the insurance company know, hey, I'm about to gut an old historic building. And I want you to extend my insurance to this. That's a big deal in the insurance world.
Counsel, can I just add one part to Justice Kafka's question? The other part is he's calling the broker. This is a change to the policy, right? So why is it even reasonable for him to think that the broker can just amend the policy in this way and not the company, not union has to do it? So the two parts to that,
Okay,
you're taking this other thing on, and then you call up and say, you got to change this for me. And it's not the company he's calling, he's expecting that the broker is going to do this.
these are all great questions. And those conversations may have happened had the broker not sent the certificate. That's the issue. It's the sending of the certificate which makes him think he's covered. Maybe he wasn't sophisticated in insurance. It's the sending of the certificate, not the certificate itself. It's the action, the physical action of sending the certificate that places my client in
Another
a,
element, if relying on that has to, going back to Chief Justice Bud's question, relying on that came over pretty quickly, that certificate, it has to be reasonable.
well, I think it is reasonable because he asked for, I need, essentially coverage. I need to be a loss payee. He was reasonable in what he
It's
received.
reasonable to rely on that? to
Absolutely,
ensure that
because it came from,
huge new property?
absolutely, Your Honor, because it came from his broker. And again, and it said for your records, not, here's
Well,
something just
isn't
for the
Me, that
Masonic
doesn't,
Temple.
that
Isn't
makes
your-
it less likely that it's something that's going to be helpful to him. If it's just for your records, that means,
Well-
here's what you have, here's what you've already got.
I disagree,
And
Your Honor.
doesn't it go even further in capital letters? This certificate is issued as a matter of information only and confers no rights upon the certificate holder. This certificate does not affirmatively or negatively amend, extend, or alter the coverage afforded by the policies below. This certificate of insurance does not constitute a contract between the issuing insurers, authorized representative, and the certificate holder, right? That's in bold print. Even the insurance company's
Wachowski,
spoken clearly. I mean, the broker's spoken clearly, hasn't?
I mean, in the court in Wachowski, I believe, again, I believe it's the actions. I'm not arguing, I understand the statute on the certificate. I'm not arguing that the certificate itself provides. What I'm saying is that the action, this is a simple negligent case. When you get a request and you don't understand what that request is, and you assume something and you provide a person who is not in the insurance industry with a document, that's the negligence. That's the catch. And I do think it's reasonable for him to rely upon the fact that he has retained the services of this business. He's provided the document at his request. And again, I think it's an issue of fact, and it's not an issue of law, Your Honors. I mean, now a jury could come back and say, well, maybe that's not reasonable. But the question is, that's not for the trial judge. I mean, the judge who wrote the summary judgment opinion. So that is an issue, and I keep going back to it, but a fundamental basis of summary judgment, we're not going to get into that. We all know the standard.
Okay.
And that.
No, we get it.
Yeah.
It's an issue of fact that he shouldn't have decided for himself. Okay, thanks.
Thank you so much.
All right. Okay, Attorney Maslett.
Good morning, Your Honors. To please the court, my name is Robert Maslick, and I represent Union Insurance Company and Acadia Insurance Company. We would urge the court to affirm the trial court's grant of summary judgment in this matter and hold that to us, the issue is that the insured risk here is the Super 8 motel, and that since the allegations in the underlying case didn't involve operations of the hotel or allegations that the hotel was involved somehow, that there was no duty to defend. Just to clarify a quick point, the that was raised in page 82 of the record on the policy. This 81 and 82 are, there's a few declarations pages. This policy is for a business. It's a combined first-party property and third-party general liability policy. So there's actually a declarations page. They all identify the insured as Dipika Inc., DBA Super 8, but there's a property specific one, a general liability, and then an overall common one. And so this one that we were looking at earlier is the right one, is the commercial general liability one. And so there was, the Masons indicated, well, there's no evidence as to how the premium is calculated. The premium is reflected in 82 is calculated based on the motel's revenue. So that's the rating classification. That's the type of building that the Super 8 is. That's where it fits into. There's multiple classifications depending on what the type of business is.
It's not the clearest thing in the world, though. Everything relates to this page 81, although maybe it doesn't, but it goes named, insured, and address.
Correct.
So that kind of blurs it a little bit, doesn't it?
Well-
And because we also go to, on the corner, but it says agency name and address. And it's Roblin Insurance, 144 Gold Street. You know, it's not drafted as clearly as possibly.
Well,
I'm not saying it's not clear enough, but there is, by putting the insured and the address in the same thing, it gets a little weird, a little harder to interpret, doesn't it?
yeah, I mean, the property coverage covers that location. It covers the Super 8 location. If there's a first party loss there, if the roof blows off,
Yeah, but then let's turn to the next page for a second. Why does it have plural, hotels and motels less than 4 stories? Is that it's a classification? Is that, it says Massachusetts location. I'm just trying to get a sense of why.
yes, Your Honor, if you look at the top, it's for Massachusetts location number 1,
Mhm.
and location number 1 on page 91 of the policy is identified as the Weymouth Hotel. It's to clarify that the premium, so this is the general liability premium.
So there's only, meaning there's only one location? Location schedule, location number 1, when we turn to page 91, is that right?
Yes, the policy covers from the property that location, and for general liability, it covers the operations of that hotel. Now, just to quickly get into it, there's an argument that, oh, we might have intended to use a designated premises endorsement, which would limit the scope of the coverage to incidents that happened at the hotel. Someone slips and falls in the lot or something like that. And the union underwriter testified at the 30B6 deposition that really wasn't the intent at all. It's to cover the operations of the hotel.
Right. If
And I'll
have a-
concede
if
that a
they have
hotel-
a shuttle bus that goes
Right.
somewhere.
Yes.
And the shuttle bus hits somebody, they're covered.
Right. It's hard to envision what a hotel could do out, but there are things that could happen. And that's the GRE case where that would be the GRE case if the hotel people were out doing things other places. And that likely, you can't tell, likely would have been covered. So that's just to clarify that the premium is in there. And this other notion that this whole coverage determination is based on a sole or single reference to it. And I'll concede, well, there's multiple in the declarations pages. But if you look at the second most important part of the policy, which is the basic coverage form, which is it contains the insuring agreement, and it's a standard industry form. In the preamble, it identifies within that form you and your, and defines those terms as the named insured. And then it defines a term insured, refers back to a different part of the policy, also would include the named insured. So every time in the form, not to be flipped, there's hundreds and hundreds of reference, if you do just regular contract interpretation and incorporate that definition, every time the form says you, it's putting Dipika DBA Super 8 right in there. So the basic coverage grant is we will pay those sums that Dipika Inc. DBA Super 8 becomes legally obligated to pay as damages.
From this record, do we know anything more about Dipika Inc.? Does it have other activities?
There's a lot of discovery about that. I believe when it first got the policy, no.
Mhm.
I would contend that Mr. Patel wears his Dipika hat, his Super 8 hat, and his personal hat. And as the Masons recognize, if the case gets remanded, we will have to litigate whether he was
And
Dippico or
does this
himself.
record indicate that you also insure these other entities of his?
No,
So you're only insuring Dippica Inc. doing business as in your.
yes, there is a citation in the record. It's in my
And can I
brief.
ask a follow-up question? In this record, and I haven't read this record yet, in this record, is there going to be indications that other aspects of his business are insured by someone else?
Yes, in fact, he testified at his deposition that he was involved in multiple other, either owning himself or with other people. I believe it's 5 or 6 other endeavors, and that it was his practice to have a separate policy for every endeavor.
And with different insurance companies?
Not with Union.
But again, I'm just relying on the record. The record will show that Mr. Patel or Dippica Inc. has different insurance policies for different parts of its business.
I don't know that those other businesses are owned by Dippica Inc. I don't believe
Okay.
they are. I believe when this policy incepted that this was the only, it was the only thing that Dippica did. We would rely on some recent cases of this court. The
Before you do
Dorchester.
that, can I ask you one other
Sure.
follow-up question? The motion judge points out that there's not builder's risk and that this is really a builder's risk type of insurance. If there was building on this property on the Super 8 in Weymouth, would it be covered, the building, would it be covered under your policy?
We'll see. I believe that that's sort of conflating the property, first party property, but third party liability. So arguably it would be covered by the first party liability.
Okay,
That
so
covers the property if it
You're
gets
not
damaged.
talking to insurance lawyers, so slow that down a
Sorry.
bit. So go
Sorry.
do that again.
So coverage for the building itself, even if it's caused by Mr. Patel or somebody else, would be likely a covered loss under the property without regard to fault or anything. It's just, there's a roof blew off and it gets fixed. This coverage we're dealing with today is general liability policy. So it would cover the general liabilities of the Super 8 motel is what we would argue. Again, shuttle, something else, or somebody sues them. It's designed for somebody suing them for
Correct.
some
CGL
wrongdoing.
stuff.
And so here, we basically say, you don't get to those other endorsements or anything because you just don't get in through the front door. The first thing you have to consider is who is the insured in this case. And here, there was just no allegations that the Super 8 was involved in any of that. And recently in Dorchester Mutual versus Crussell, and earlier in First Specialty versus Pilgrim, there's the two principles that I think, although this is a matter of first impression, if you apply these rules, I believe the answer is obvious, and that's that every word in insurance policy should be given effect if possible, and that an interpretation of the policy that gives effect to everything is favored over one that would render language meaningless. And so at the end of the day, you just have to ask yourself, if the policy wasn't intended to be limited to the operations of the Super 8, why would you ever put the DBA limitation in there? And to address why, and the fact that nobody knows what it means, there is evidence in the record that they do. When Brovlin obtained the policy, the application for quotations indicated Dippica DBA Super 8. And the testimony was that was done to make it clear that they were just seeking quotes for the operation of the Super 8. So ultimately, because the Super 8 wasn't involved, that's why there's no coverage here.
The problem, though, with your argument is that at the time the policy was obtained or issued, the only operation of Dippica Inc. appears to be the Super 8.
True, but I don't believe that should be determinative. It's the Super 8 was, Dippica was free to do. It could have, maybe it might be in this case that it went and got itself involved in this Masonic temple project. And in that case, our argument is it just doesn't fit under the insuring agreement because it wasn't operating as he wasn't wearing his Super 8 hat when he was doing it, and there were no allegations that he was.
But if he did it right, so say in your view, I know you say he didn't do it here, but if Mr. Patel had called up Union Insurance and his broker and said, I bought a new property I want to insure it. Does the insurance policy cover how that should be done? Does it require that you add the location? Does it require additional premium? Do we have guidance from the document itself about how to do with that?
No, because I believe earlier there was a reference to this newly acquired property
Right.
issue, and that's in the property coverage. So
Property.
yes, if he bought a new building and he wanted it to be insured under this policy, he would have to go out and tell the insurance company about it and pay a premium for it to get property coverage for it. And whatever entity was, you know, he'd have to have general liability coverage for whatever entity was doing the work over at the Masonic Temple.
So, but what if he decided, you know what, I'm going to call that entity Super 8? Then what?
Well, I'd argue that it's Super 8, and I believe there's no question it's a Super 8 in Weymouth. So I would still
No,
say.
but that's as to the location. We're
Yes.
talking, as you explained.
Yes.
About the general liability insurance. And your general liability insurance covers doing business as Super 8. So if he said, I'm doing business as Super 8 while I'm working on the temple, why, what's your argument in response?
That would be if there was, or we're only dealing with the duty to defend. So if there was allegations that the Super 8, that he was wearing his Super 8 hat when he was doing this Masonic Temple project, there likely would have been a duty to defend. You know, there just were no allegations. It was just Dipika that was doing it, or that was alleged to do it. And there are sort of dueling cases from other jurisdictions that we've raised. I think
Because,
ours.
could you flesh that out a little bit? Because I'm trying to, I want, is it just the name? It's just using the words? So I'm confused by that, particularly in light of his request to the insurance broker, right? What is his request to the insurance broker? Does it use the word Super 8 in there?
No, he uses the word lost payee on his policy, which is I'll admit, I'll concede this was the only policy he had that was at issue.
But if he called up and said, I've turned the Mason, I just bought the Mason property and I'm running that, I'm going to run that as the Super 8 of wherever the town that the Mason property is in. Is that create a duty to defend on your part?
No. What creates a duty to defend are the allegations. So if the allegations against him were that somehow the Super 8 motel was involved, even though those allegations would be meritless, there's still a duty to defend.
If he's expanding his brand, he's creating another Dipika Inc. Super 8.
Right.
And he's going to do it out of the Mason Hotel. And that was what is in his head, that I've created Super 8, you know, like the Hilton. I've got another Hilton going on here. Do you have a duty to defend under this policy if that's what he alleged?
Well, no, because the focus isn't on what disconnect, I think, is that's not the focus on what he's alleging. It's on what the
Basins.
person suing him is alleging.
Right.
So it would depend on what they alleged. And I'd submit if he was making a different Super 8 someplace else, that there still wouldn't be a duty to defend. This policy is related to the risks arising out of the operation of that Super 8 in Weymouth. So if it's alleged that the Super 8 in Weymouth was doing something wrong.
Because
or hurt somebody-
aren't they sort of alleging? I understand they're not saying the Super 8 doing business with that particular address, because they're cutting off the address. But are they arguably alleging that he was doing business as Dipika Inc. Super 8 in the Mason area, or are they not alleging that?
My response would be that they.
Again, we have to take the facts in the light most favorable to them from this record.
My argument is that they cut off the Super 8 DBA in their arguments here, in every argument, they don't like the DBA Super 8, but they didn't allege it in the underlying case either. And so just real quickly, there are cases from other jurisdictions. I think ours are more in accord with Massachusetts, where people got involved in two different businesses. The insurance was related to one and got in trouble in the other, and that there was no coverage because it was, the bottom line is there is no need to put that language in there. If it has to mean something.
Okay, thank you very much.
Thank you.
And finally, we have Attorney Chapman.
Morning, may it please the court. I'm William Chapman. I'm counsel for the appellee Roblin. Over the last 40 years, the Supreme Judicial Court and the Mass Appeals Court have bestowed us with a significant body of case law which defines the rights and responsibilities of insurance agents and brokers and producers in Massachusetts. And these cases provide the practitioner, the public, and the professional with a pretty clear roadmap. It's a roadmap which pretty clearly defines when an agent may or may not be found liable to its customers, such as Dipika, or to a third party, such as the Masons. And we respectfully suggested in this appeal, the appellants, both appellants, ignore this roadmap. As a matter of fact, as I stand before you, what we've heard so far is not a single word from the Masons. Now, because we have two very distinct claims here. We have a third-party beneficiary claim made by the Masons, and we have a direct E&O claim by
Why
Dipika.
isn't your client's negligence a question of fact?
It's not a question of fact because there was no genuine issue of material fact here.
Well, the insured leaves right over here. The insured leaves a message that's unintelligible. You provide a document that is non-responsive. And then you leave a message or an email, and again, it's not responded to. Why isn't that a question of fact that needs to go to the jury?
Because it's an extreme departure from the type of request that is actionable in a case like this. I believe what the judge found is that Mr. Patel's request on the telephone, and again, I'm going to quote from it, "I need to do a name loss payee of Quincy Masonic Temple Associates, and this is something I need right away."
Well, he actually said, I need a rider for Dipika Inc., right?
That's the email. The phone message was, "I need to do a name loss payee of Quincy Masonic Temple, and this is something I need right away." The email was, "I need rider for Dipika Inc. name Quincy Masonic Temple Association loss payee." So I believe the judge found that that's not the type of request that's actionable. And the judge was also considering that phone message and that email. We agree that those are the only two communications in light of the record surrounding the request. Okay, and we start with, and there's extensive evidence in the record of what led to that phone call and that email. It starts with the Mason's own lawyer, Mr. Levin. This is at record Roman numeral 466. "I need an insurance certificate." Then we have the Mason's principals, Mr. Elsner and Mr. Smith, testifying, "We stopped the work that Mr. Patel was doing in the building until he provided a certificate of liability insurance." And that was Mr. Smith's testimony. Mr. Elsner testified, "You have to stop work until we have a copy of the insurance certificate." And then we have Mr. Patel. Now, this is very important. Mr. Patel testifies, and I'm now referring to Record Appendix 3595. "I got a phone call from Mr. Elsner. Mr. Elsner, he asked me to send him a certificate of insurance. And so Mr. Elsner called you?" "Yes." "And he said he needed you to send him a certificate of insurance?" "Yes." "And are you saying as a result of getting that phone call from Mr. Elsner, you then placed that voicemail phone call to Roblin?" "Yes."
But counsel, there's a problem here. You have all of these folks, to allude to Justice Kafka's earlier point, that aren't in the insurance business. Okay, they're not in the insurance business. And it's clear that what the concern the Masons have are that we are covered if something goes wrong. They're not necessarily interested in making sure that Patel has a certificate of insurance that covers anything that he's doing, covers him. They want to know that they're covered, right?
I disagree with that, Your Honor. That's typically not the purpose of a certificate of insurance, and Lauren Luke testified to that.
Sure, but Lauren Luke's testifying in favor of your position. I'm talking about for the other side, right?
Okay, so-
So in the conversations that they had with Patel, they wanted to be sure that they were somehow covered if something were to go wrong.
No, that's not the record, Your Honor. That's one of the interesting things about this case. The Masons were unanimous in their testimony. We're just asking for a certificate. We want to be covered. And that's
Okay.
that's not unusual.
But they don't want a certificate in an abstract way. They've got some guy doing construction work on their historic giant building. And they want to know if he sets the place on fire that they're covered.
Sure.
That's what they're asking. Now, they may be negligent themselves in how they respond to all this.
Right.
But they want coverage for the construction going on in their building. That's obviously what they're asking. And then Mr. Patel calls up your client to give them that, but he doesn't explain that to your client. He just says, I need a Dipika with paying loss to the Masons. Does your client have an obligation to say, huh?
We say absolutely not, Your Honor. And the case law is crystal clear. The Masons, what their motivation is, what they want from Patel is irrelevant unless there's evidence in the record on summary judgment that Roblin has actual knowledge of that. Roblin has to know, and this is the Quigley case that I was personally
Not all
involved in.
that's left, the liability between Roblin and the Masons. Isn't there a separate question of the liability of Roblin to Dipika?
Sure, yeah.
Okay, so
That's
sticking with that liability.
okay.
Why
so-
isn't there still a question of fact as to whether or not your client was negligent when they get a voicemail and an email that's unintelligible? They provide what they think is responsive, and then, they send an email and then nothing.
Well, the first thing I'd say to that, Your Honor, is we're talking about a claim that was not pleaded. The negligence claim of Patel was premised upon a specific request that Roblin bind sufficient builder's risk coverage to cover the cost of replacement of the building and contents of the Masonic temple. That's not what Mr. Patel said on that voicemail. And that's not even close to anything Roblin knew of or agreed to. Again, it's summary judgment is to discover whether or not there's a genuine issue of material fact. Patel's voicemail and his email, they don't raise a genuine issue of material fact because what he was asked, what he had just been asked to produce, and what was in his mind, Mr. Schreckinger's own questions elicited this. What was in his mind when he said those words was he wanted a certificate of insurance. And then he got a certificate of insurance. And then Roblin followed up to say, are you sure, this is what you want? What is the relationship? Mr. Patel freely admits, I didn't get back to them because I got what I wanted, a certificate of insurance.
Is
So,
there a duty? I'm over here. Is there a duty to nudge a little more than a call and an email when the stakes might be?
No,
pretty
Your
high?
Honor, that's Radin versus Church and all the cases that come after it since 1958. The duty that applied here, and we heard Mr. Lawler acknowledge that this is not a special circumstances case. And if it's not a special circumstances case, the duty is to obtain the requested insurance. And that's what was done. Mr. Patel admitted that in his deposition. He admitted that he came to us, he asked us for motel insurance for the Super 8 in Weymouth, and we got that for him. He also asked for workers' comp for that operation. We got that from him. We, at all relevant times, fulfilled the duty. We obtained the requested insurance. And in this situation with the certificate, we went one step further than we needed to. We did a follow-up call, and Mr. Patel didn't bother to respond because he got what he had been asking for, which was a certificate of insurance, not separate coverage for a Mason's building, not separate coverage, which he knew he needed. He testified to that, and that's in the summary judgment record. You go into a new business, you get a new operation, you get a new policy. He did testify, and Mr. Maslick was correct. There's a whole list of other operations he was involved in, other motel operations, none of them through Roblin, none of them through Union. But he knew for all those other operations, he had to get a new policy every single time he did that. And does this voicemail and does this email, does that amount to a request for insurance for this significant Masons project? Not even close, Your Honor.
Okay,
Thank you very much.
Thank you, Your Honor.
We'll take our morning break.